These days, we don't just divide houses, cars, and retirement accounts in a divorce. More and more, we're seeing digital assets become a major part of property division here in Arizona. From cryptocurrency and online businesses to digital royalties, even cloud storage accounts. These assets matter during divorce proceedings. I'm Sarah Manning, a family law attorney here at Provident Law in Arizona. Today, I want to talk to you about how digital assets are divided during a divorce and what you need to know to prepare. If you're going through a separation or considering divorce, understanding how Arizona law handles digital property can make a big difference in your financial future. And if you'd like to talk more about your specific situation, please reach out. We'd be glad to guide you through it. Arizona is a community property state. That means, in general, anything you acquire during the marriage, whether it's a traditional asset like a house or a digital asset like cryptocurrency, it is considered community property and will be equitably divided. Now, what falls under digital assets? Think broadly, like cryptocurrency or Ethereum, NFTs, online businesses or digital storefronts, or YouTube channels or other monetized content. It can also include royalties from digital works, cloud accounts filled with valuable data, and even things like airline miles or digital subscriptions. All of these things may hold financial value, and the court may consider them when dividing financial assets. Here's where things can get tricky. Digital assets are not always easy to trace, and one spouse might try to hide them. Cryptocurrency, for example, can be stored or transferred in ways that are hard to detect if you don't know where to look for them. This is why full financial disclosure is required in Arizona divorces, and why working with professionals, attorneys, and sometimes financial accountants is important. Another issue that often comes up is marital waste. Even though Arizona is a no-fault divorce state, meaning the court doesn't punish a spouse for adultery or other misconduct, misusing marital funds on the affair or excessive spending on personal digital accounts can affect the division of assets. If, for example, a spouse spent thousands of dollars from a shared account to buy cryptocurrency gifts for someone else, or funded online accounts to support the affair, the court could consider that marital waste. In that case, the innocent spouse may be entitled to a greater share of the remaining community property to make up for that loss. So, what should you do if you're concerned about digital assets in your divorce? First, gather as much information as you can. Account statements, login information, and transaction histories. The more documentation you have, the easier it is to prove the existence and values of those assets. Second, don't assume that just because something's online, it's untouchable. Arizona courts view digital assets the same way they view physical ones. If it has value, it's divisible. And third, get legal help early. An experienced attorney can guide you through disclosure, valuation, and division to make sure that nothing important is overlooked. Arizona treats digital assets just like any other community property. They're subject to equitable division, they can be traced and valued, and they can even come into play if marital waste is involved. The key is preparation. Knowing what assets exist, documenting their value, and protecting your rights during the process. If you're facing divorce and digital assets are part of your picture, please don't try to handle this alone. I'm Sarah Manning at Provident Law, and our family law team helps clients navigate these issues every day. If you have questions about your specific situation, we'd be glad to sit down with you and walk through the best way to protect your future. Reach out today and let's talk.